Hello friends, my name is Advocate TK Kaushik and you guys are watching my video blog. In today's video blog we will talk about how to defend your case before Enforcement Directorate or how to defend the ED case, what sort of litigation strategy one should basically make, and how basically one should move forward when you are in litigation before Enforcement Directorate. So let's begin with today's video blog. If you've not subscribed to my video blog, do subscribe to my YouTube channel, and throughout the video you will see my social media details as well as contact details. In case if I can be of any help, I'll be more than happy to help. Let's begin with today's video blog. So friends, first of all, understand when it comes to ED case either can be of FEMA, which is complete act is Foreign Exchange Management Act 1999, or offenses and penalties under the Prevention of Money Laundering Act, which is known as PMLA, which is an act of 2002. Now understand, while we are discussing to ED case here, we are discussing penalties versus criminal liability related to the ED case. We will also discuss about the burden of proof. We'll discuss about the how and on whom the burden of proof lies when it comes to the Enforcement Directorate case. We'll discuss bail provisions under PMLA Act. We will also talk about what are we supposed to do while we are defending a case before ED. And let's quickly begin. First of all, understand that Enforcement Directorate is a multidisciplinary institution or organization which basically work to make sure that these two laws are enforced. One, like I said earlier, which is FEMA. Second is PMLA. I have already given you the complete abbreviation of these both statutes earlier. Now, understand that when it comes to Enforcement Directorate case, this case can be a criminal versus civil in nature, so you require your legal team to be sound in terms of civil versus criminal litigation. Now, first of all, understand FEMA. So FEMA is Foreign Exchange Management Act 1999. This act says that if anyone who basically doesn't follow the statute, rules, regulations, notifications, orders, etc., that person can be penalized with the penalties, which can sum up to the 3 times of the amount in question, or they can be a penalty up to 2 lakh rupees if the amount is not quantified. Third, in case if you're in violation of FEMA Act, there can be an additional penalty which may extend to 5,000 for each during day when you happen to continue these violations of FEMA. Now let's understand what basically happens under PMLA. So when we talk about PMLA, so PMLA, like I said earlier, which is the Prevention of Money Laundering Act 2002. Here, offenses versus penalties, because it has a criminal nature. So it says as per the statute, there can be a jail term which may be at least 3 years, and which may extend up to 7 years. Now also understand that the period here may also extend up to 10 years, and there can be penalty up to 5 lakh rupees. So this is basically can be a damage under Prevention of Money Laundering Act. Now understand the criminal versus civil liability of these both statutes. So when we talk about FEMA basically the act which is in place right now, it basically repealed the FEMA Act, which is which basically repealed the FARA Act of 1947, which stands as Foreign Exchange Regulations Act. Now understand that in FEMA there are more strict penalties versus FARA. So this is what it is. It's basically civil in nature statute. So a person may be liable for a civil imprisonment if the penalties are not paid on violations of FEMA. Okay. Now, when we talk about PMLA here, so it's a criminal offense. If anyone does the violation of PMLA Act, basically, person here may be accused of money laundering in India. So here, that person can be punished with fine as well as imprisonment both. Now, you might have seen very many cases nowadays wherein agencies are very strict, looking into how money laundering basically happen. So based on the Supreme Court's latest judgment, you might have seen that now when it comes to how they can investigate, the judgment by the Honorable Supreme Court has been given in the favor of the agency. So agencies are given permission to investigate the matter as if when they believe that it is a matter under PMLA. Okay. Now let's understand under FEMA who basically has a burden of proof. So it is a well settled law that the onus of proof, whether the civil or a criminal, is on prosecution, not on the accused person. So before the law, accused person not found guilty, he's an innocent person. Okay. Similarly, let's talk about in PMLA, if the accused person is charged with the money laundering act, so the money laundering must be proven in the court against that person until the time that that person has been convicted by the court. When it comes to onus of burden of proof, it basically lies on the agency. Okay, so FEMA and PMLA does not basically impose reverse burden of proof on accused person. Burden of proof, which means that the agency, which is Enforcement Directorate, will have to prove their case before the competent court or the authority. So that's something we'll have to understand. Now let's talk about, since we've discussed Prevention of Money Laundering Act, we've understood that it's a criminal statute in nature. So Section 45 of Prevention of Money Laundering Act 2002 says that when when person is basically apprehending arrest or person is made and accused of money laundering, it's a cognizable offense, but it's a non-bailable offense. Okay, so we need to understand that when offense is non-bailable, if the punishment of that violation is up to 3 years, bail may be granted. Otherwise, when the offense is such wherein it's more than 3 years, so in that situation, bail application has to be moved before the court, and the twin condition has to be satisfied that that person will not continue with that offense. Due notice is supposed to be given to the other side, which is to the agency, and then how it is there in the Code of a Criminal Procedure, those conditions will be imposed on that accused person in the event of if the bail is granted. And getting a bail in PMLA case depends primarily on the kind of offense which is being charged on that accused person. So that's what it is. When the bail is granted, one has to furnish the bail bond and will have to satisfy the court concern related to the terms and conditions of the bail. Okay, person will have to make sure, obviously, which is there in a criminal or civil offense, that you'll have to appear before the court going forward when the trial is pending, before the honorable court. Now, what we need to basically keep in mind while we are into a ED litigation, we need to make sure that we get in touch with the lawyer who's got credentials and expertise related to handling a ED case, depending on FEMA versus PMLA Act, because here you require expertise related to civil versus criminal law, Agencies are well equipped, so you need to make sure that you require somebody who can create a solid defense for your case. This is very important. Now, something very important that you need to understand, that a statement made before ED is not binding. Now, Supreme Court has also said in one of the judgments, which is the Tajuddin versus Union of India, that if accused person has made statement before the Enforcement Directorate, before the agency, such statement shall not be sole basis of establishing the guilt of the accused person. Okay, those are supposed to be proved during a course of a trial before the honorable court. So we need to understand that we find a good lawyer who's got understanding of how to handle a complex litigation before Enforcement Directorate. We'll have to make sure that while even we've given the statement before the ED that's not binding on an accused person, there is supposed to be relevant evidence against accused person going forward. Now, there's a misconception related to attachment of the property, that in case if it's an ED case, ED will attach the property will remain with the ED. Here's the thing: when it comes to attachment of the property, that attachment of the property is only up to 180 days. So and then again, during the course of a trial, you will have to prove your innocence, and this will only be done by a way of making sure that you created a solid defense for yourself. Now, if the ED is relating yourself to a money laundering case, understand it's a criminal case in nature, one has to make sure that while you are preparing your defense, monetary transaction was involved or not. If the monetary transaction was not involved, ED pro cannot be done against accused person or against any individual. So friends, this is a small video blog which is related to how to create solid strategy by which you can defend your case before agency such as Enforcement Directorate. Again, like I said, you need to make sure that while you are in an ED litigation, you only discuss fact of the matter related to your case with your lawyer. You need not to make sure that you are gaga about the factors of the case or your defense. You need not reveal your defense because you'll have to face the trial. Make sure that you hire a good lawyer who's got very solid knowledge related to the statutes, be it Prevention of Money Laundering Act or be it FEMA. Civil versus criminal knowledge to conduct a trial is very important of that lawyer. Make sure that, and you do not have any apprehension to the fact that even if the ED attaches your property, this will remain for forever. This is only up to 180 days. You'll have to make sure that you understand criminal versus civil liabilities of it. You'll also have to understand that there is a scope under Section 45 of PMLA Act when the proceedings are against you related to the Prevention of Money Laundering Act 2002. You'll just have to satisfy the twin condition before the court in order to get a bail. Throughout this video blog, you might have seen my social media details. In case if I can be of any help, I'll be more than happy to help you. I practice law in National Capital Region, Delhi, Hyderabad, Mumbai, Delhi, Chennai, Bangalore, and other metropolitan cities. I have an expertise in white collar crimes, and I and my team always make sure that we do not hand over our clients under attorney-client privilege to the agency. We make sure that we work as per our statutory right of defense. And please understand, and this is a very important statement, you are an innocent person till the time the competent court pronounces you guilty of an offense or a penalty or a fine. Okay, so this is the fundamental right of an accused person. So that's what it is in today's video blog, guys. I hope I was of some help. Thank you so very much for watching. You have a wonderful day ahead. Have a good one, people.